Hello, this is a review of the Connecticut Family Medical Leave Act for 2022. My name is Heidi Lane, and with me we have Jennifer Devine and Erica Foster, who are also attorneys in the legal division at the Connecticut Department of Labor. We're going to walk through the new Connecticut FMLA that begins 1/1/22. Few things before we actually get started. I just want to stress that we have done our very best to make sure that everything in here is complete and accurate. But this does not constitute legal advice. We make every effort to make sure that it's accurate and that it's quality information, but we make no guarantees about the accuracy or completeness of the information. To start, I'm going to go over the leave laws in the state of Connecticut. So we're breaking it up into two different categories. One is the laws that provide job protected leave and laws that provide income replacement during a leave. So the first one I want to discuss under job protection is the federal FMLA. And on this chart, you will see that the federal FMLA is for employers who have 50 or more employees in a 75-mile radius, for private employers and one or more for public employers. Now, beginning on 1/1/22, the Connecticut FMLA will affect employers who have one or more employees working in Connecticut. Another job protected leave is workers' compensation. You also may be able to get a leave under the Americans with Disabilities Act, a leave under the Pregnancy Disability Act, under Connecticut's Fair Employment Practices Act, or paid sick leave. Those are the general laws that give job protected leave. But several laws also give you income replacement, and one is Connecticut Paid Leave, CTPL, which is effective on 1/1/22, and it is for employers who have one or more employees working in Connecticut, or the self-employed who have opted in. Workers' compensation gives income replacement, and so does paid sick leave. So those are the basic laws that we have on the books in Connecticut. Now, one big change in Connecticut's law beginning 1/1/22 is that an eligible individual will be able to take 12 weeks of leave every 12 months. And we'll go into the reasons why you can take the leave, how you can take the leave, and for whom you may take the leave. These are job protected leaves. So if you have to go out, you return to the same or an equivalent job. Benefits are protected. You should treat these employees as if they sat in their chair the entire time. Treat them as if they never took the leave. The employee may take up to 2 additional weeks of leave during the 12-month period if the woman has a serious health condition that results in incapacitation during her pregnancy. So this could be if she ends up with bronchitis during her pregnancy. That's a serious health condition. that could be a serious health condition that occurs during her pregnancy. So she would be able to take 2 additional weeks of leave for that, leaving her with the full 12-week entitlement for the birth of her child. So generally, what we're going to be talking about is Connecticut FMLA, the federal FMLA, and CTPL, the Connecticut Paid Leave. So for federal FMLA, nothing has changed. Again, it's for the employers with 50 or more employees, and it's 12 weeks every 12 months. It's job protected, benefits protected, and this law requires for continuation of employer-sponsored health benefits during the leave. And Connecticut paid leave, CTPL, does not have any job protection. So you can take CTPL, but you do not have job protection when you take that. It's for 12 weeks every 12 months, similar to the other 2 FMLA laws. Now, you don't have job protection, but there are times if CTPL is running concurrently with the federal or the state FMLA, those laws will give job protection while you are receiving paid leave. So we will get into some examples and descriptions later on, but those are basically the main elements of the 3 leave laws that we are discussing here.
So this slide is going to explain the lengths of FMLA leave and CTPL benefits. In the left column, we have the federal law. In the middle column, we have the Connecticut FMLA law. And in the right column, we have the Connecticut paid leave law. The federal law provides 12 weeks in a 12-month period of job protected leave, except for military caregiver leave, which is 26 weeks in a 12-month period. And this is if you are caring for a family member that has serious illness or injury and they are in the military. Connecticut FMLA leave, again, the new amended version of this, which begins on 1/1/22, also provides 12 weeks in a 12-month period and also provides up to 26 weeks in a 12-month period for military caregivers. The CTPL provides 12 weeks of paid leave, paid benefits, income replacement in a 12-month period for all reasons, including military caregiver leave. And then there is a provision in the Connecticut law is called 3151 SS, employees who are victims of family violence may use up to 12 days of leave during any calendar year in which such leave is reasonably necessary. But this doesn't affect FMLA and it is not considered FMLA. These are just 12 additional days of job protected leave under that law for victims of family violence. However, under Connecticut paid leave, that can be part of your 12-week entitlement of paid income replacement, and they can use up to 12 days of that in the 12-week period. And then finally, Connecticut FMLA provides the additional 2 weeks of leave for a pregnant woman who is incapacitated due to a serious health condition that occurs during the pregnancy, as we previously explained. And under the Connecticut paid leave, that employee can be eligible for 2 additional weeks of income replacement for the same reason. The 12-month period for both Connecticut FMLA and federal FMLA can be chosen by the employer under one of four methods. And they must choose a method and put this method in their policy. It's either a calendar year is one method. This will mean January 1 to January 1, and that'll be your 12-month period for using FMLA. Any fixed 12-month period, such as a fiscal year or first date of employment. It could be July to July, for instance. A 12-month period measured forward from an employee's first day of leave, meaning if I go out on my first day of leave on October 1, then that begins my 12-month period and ends on the following October 1. And then the final method is a rolling 12-month period measured backward from the date the employee takes FMLA leave. And this requires the employer to look back over a 12-month period to see how much FMLA the employee has used in that 12 months to determine what they may have available going forward. The Connecticut paid leave program will only be using the rolling back method. Under Connecticut and federal FMLA, there's a provision where if you and your spouse work for the same employer, there are times when you must share the total of 12 weeks available. And those times are for birth and bonding, adoption or placement of a foster child, or care for a family member. Spouses that are caring for a military member will also have to share the 26 weeks of leave. Now, it's clearly not very easy to figure out what that means, so we have an example here that'll help explain it. So, a woman gives birth and is considered disabled for 8 weeks. Her spouse, who also works for the same employer, is entitled to take 8 weeks to care for his spouse because she, after giving birth, has a serious health condition, typically for 6 to 8 weeks, depending on what the doctor says. So let's assume in this case it's for 8 weeks. So there are 4 weeks remaining for each of the spouses. However, they can only use 4 weeks combined to bond with the new baby because they have to share the weeks for bonding time. So let's assume that the wife uses 4 weeks for bonding, so that she now has used all 12 weeks of her FMLA, and her FMLA is exhausted for the year. Her spouse cannot use any time for bonding because she has used the 4 remaining shared weeks. So the spouse has used a total of 8 weeks of FMLA and has 4 weeks left remaining for other qualifying reasons that are not bonding or caring for a family member, because those are shared weeks. Say he had his own serious health condition, then he could use those 4 remaining weeks for his own serious health condition.
So the qualifying reasons for taking Connecticut FMLA, as well as taking leave under the Connecticut paid leave, include the birth of a child and care within the first year after birth, the placement of a child with the employee for adoption or foster care and care within the first year after placement, to care for a family member with a serious health condition because of the employee's own serious health condition, for the employee to serve as an organ or bone marrow donor, for the employee to address qualifying exigencies arising from a spouse, son, daughter, or parent's active duty service in the armed forces, or for the employee to care for a spouse, son, daughter, parent, or next of kin with a serious injury or illness incurred on active duty in the armed forces. It's important to note here that the definition of family member is much broader under the Connecticut FMLA and the Connecticut paid leave law. The federal FMLA is pretty limited in the individuals for whom an employee can provide care, and that is generally the employee's spouse, son, daughter, or parent. and that incorporates the in loco parentis concept, but that is as broad as that particular law gets. So there are two qualifying reasons for leave under the Connecticut FMLA that relate to military service. The first is military caregiver leave, which provides up to 26 weeks of leave for an eligible employee who is the spouse, child, parent, or next of kin of a current member of the armed forces, where that service member is undergoing medical treatment, recuperation, or therapy, is in outpatient status, or on the temporary disability retired list for a serious injury or illness incurred in the line of duty. This particular leave, military caregiver leave, applies on a per service member, per injury basis. So the employee may receive up to 26 weeks of leave to care for a different service member in their family, or to provide care to the same service member with a different or subsequent injury or illness. But the employee can get no more than 26 weeks of leave in any 12-month period. It's also important to note for military caregiver leave that the 12-month period begins on the first day the employee takes leave to care for the service member and ends 12 months thereafter, regardless of the method that the employer uses for calculating the leave period for other FMLA qualifying reasons under its policy. The second qualifying reason related to military service is the qualifying exigency leave. And this allows the employee to take up to 12 weeks of leave where the eligible employee's spouse, son, daughter, or parent is a military member on covered active duty. And the qualifying exigency reasons include leave to address short notice deployment, military events and related activities, childcare and school activities, financial and legal arrangements, counseling, covered service members' rest and recuperation, post-deployment activities, and additional activities agreed to by the employee and the employer. So this table lays out the various eligibility requirements amongst the three laws that we've been discussing so far. In the first column, under the federal FMLA job protected leave, in order to be eligible, an employee must have worked for the employer for at least 12 months, and the employee must have worked at least 1,250 hours in the 12 months immediately preceding their leave. Under the Connecticut FMLA, an employee now only needs to work for the employer on a consecutive basis for the 3 months immediately prior to their leave. And under the Connecticut Paid Leave Program, it's a monetary threshold for eligibility, so the employee must have earned at least $2,325 in the highest earning quarter of the first 4 of the past 5 quarters, and that can be money earned from one or more employers. Additionally, the individual either has to be currently employed and working in Connecticut, must have been employed and working in Connecticut during the past 12 weeks, or the individual must be a sole proprietor or self-employed individual who has opted to participate in the Connecticut Paid Leave Program. As far as the employers that are covered under these laws, it generally applies to any employer that has 1 or more employees. The exceptions, so those employers who are not covered, include municipalities, local or regional boards of education, non-public elementary or secondary schools. It is important to note that under the Connecticut Paid Leave Program, certain unions can negotiate to be included in that program. As far as the Connecticut FMLA, it's important to note that the state is deemed to be a covered employer. And for federal FMLA, that law applies to private employers that have 50 or more employees within the applicable geographic region, as well as to all public agencies, be them federal, state, or local. And here is a list under the Connecticut Paid Leave Program for those individuals who are deemed to be covered public employees. So all non-unionized employees of the state of Connecticut are covered. unionized employees of the state of Connecticut who collectively bargain to be included in the program. For employees of municipalities, union and non-union employees can be covered if the unionized employees of the municipality collectively bargain to be included. And the same goes for employees of local and regional boards of education. Both union and non-union employees will be covered if the unionized employees collectively bargain to be included.
Now we're going to go over some of the definitions that are used in both CTFMLA and CTPL. Family member is pretty broad. It means a spouse, sibling, son or daughter, grandparent, grandchild, or parent, or an individual related to the employee by blood or affinity, whose close association the employee shows to be the equivalent of those family relationships. So for the individual whose close association is the equivalent of a family relationship, there has to be a significant bond between the two people. It can't just be a neighbor who you've known for a long time, but you don't have that close of an association that is equivalent to that of a family relationship. And the employee will need to provide a simple written statement about the relationship. And but something that's very important to note is that the federal FMLA definitions are much narrower. So there are going to be times, which we will get to, where the leave might be covered by both CTFMLA and CTPL, but not covered by the federal. And we will get into some examples a little later. The definition of a grandchild is related by blood, marriage, adoption by a child of the grandparent, or foster care. And the grandparent is someone related to a person by blood, marriage, adoption of a minor child by a child of the grandparent, or foster care by a child of the grandparent. Neither of these categories are in the federal FMLA. So this is, if you're taking a leave for a grandchild or a grandparent, it is not going to be covered by the federal FMLA. Sibling, biological brother or sister, half-brother, half-sister, stepbrother, stepsister, adopted brother or sister, foster brother or sister, brother-in-law or sister-in-law of the eligible employee or the employee's spouse. So this is a rather broad definition of sibling because it covers in-laws as well, along with all the other criteria that's explained in the definition. Federal FMLA does not include siblings. For CTFMLA and CTPL, son or daughter means a biological, adopted, or foster child, stepchild, legal ward, or in the alternative, a child of a person standing in loco parentis, or an individual to whom the employee stood in loco parentis when the individual was a child. Now, what that basically means is son or daughter, we know those terms, but if I was brought up by, let's say, an aunt who cared for me as I was growing up, day-to-day responsibility for me, that I am considered a child of that aunt because she is standing in loco parentis in place of the parent. So I would be able to take a leave for her, and she would be able to take a leave to care for me. Now, for Connecticut FMLA and CTPL, the child may be of any age. That is different from the definition in the federal FMLA. So there are times when the leaves will not be running concurrently with the federal FMLA. Part of this law, because the legislature understood that there are going to be times when you need to bring in a temporary employee to help out while someone is not, when someone is out on leave. Once that person on leave comes back, remember they have to come back to their same job. So the employer will have to terminate the employment of the temporary worker. Well, the employer will not be charged unemployment compensation benefits for the person that they've had to terminate due to the return of their employer from leave. So that is one thing that employers will not have to worry about. They will not get charged for anyone that they have to terminate due to the return of an employee who has been on leave.
So under all three leave provisions, you can take leave to care for a family member. What does that mean, to care for a family member? It does actually mean both physical and psychological care. So the more obvious one is my spouse needs me to care for them physically in terms of getting them meals and medicine and taking them to the doctor, those kinds of things. But my spouse could also need psychological care. So even if my spouse is in the hospital, the doctor could decide that I'm needed to be with my spouse to care for them and provide support in that psychological manner, even though everyone in the hospital is taking care of my spouse's physical issues. It also includes situations where the employee may be needed to fill in for others who are caring for the family member, or to make arrangements for changes in care. For instance, if I am putting a parent into a nursing home, or needing to change a parent from the hospital to a rehabilitation facility. Those kinds of appointments can also be covered by FMLA. Okay, now we're going to go through all the different categories of what a serious health condition is. And again, this is all covered in the same way by Connecticut FMLA, federal FMLA, and Connecticut paid leave. So the first category, it's an illness, injury, impairment, or physical or mental condition. And the first category involves inpatient care and treatment therefore, or recovery therefrom. So inpatient care, what they mean by that is an overnight stay in the hospital. You have to be admitted to the hospital. It's not an ER visit, and it has to be overnight. So one overnight inpatient admittance to a hospital automatically would qualify as a serious health condition. This also comes up with a rehab facility, that kind of thing. The second definition of serious health condition is continuing treatment by a healthcare provider with incapacity of more than 3 full consecutive calendar days. And what that means is, I work Monday through Friday. I am sick Thursday, Friday, Saturday. that's 3 full consecutive calendar days, so that by Sunday, if I'm still ill, that qualifies as more than 3 full consecutive calendar days. Then I also have to have 2 or more treatments by a healthcare provider. That means I have visited a healthcare provider either in person or through telehealth within 7 days of the first day of incapacity. And then I have a second visit with a healthcare provider within 30 days of the first day of incapacity. And what we're looking for is a healthcare provider that requires the second visit. There is a third definition that is similar to the second definition. We have continuing treatment by healthcare provider with incapacity of more than 3 full consecutive calendar days. And we do have that first visit with the healthcare provider within 7 days of the first day of incapacity. But instead of a second visit, what we have is a regimen of continuing treatment by the healthcare provider, meaning the healthcare provider has either given me a prescription for medication or has given me a prescription to go get physical therapy or to get oxygen, something along those lines. And under all of these provisions that talk about incapacity, what that means is the inability to work or go to school or perform other regular daily activities. So you do have to be incapacitated from those kinds of things to have it qualify as a serious health condition. The fourth serious health condition is any period of incapacity because of pregnancy or prenatal care. And a doctor's visit at the time of each absence is not required. So specifically, if you're having morning sickness, you clearly don't need to be seeing your OBGYN every time you have morning sickness. But you can call out with FMLA under that provision. The other thing we'd like to point out is something called the Pregnancy Discrimination Act. This is under the jurisdiction of the Commission on Human Rights and Opportunities. Heidi, the slides are going forward and we need them to go backwards.
I will get back there eventually.
Okay, bear with us. There we go. So in Connecticut, a pregnant employee is entitled to a reasonable leave of absence for the period of disability resulting from the pregnancy. So this is a completely separate law from FMLA, and it does protect the woman's job. So even if you're not eligible for FMLA, say you've only been employed 1 week, if you're pregnant and your doctor puts you on bed rest, you will qualify for job protection based on this Pregnancy Discrimination Act. As long as your doctor says that you are disabled as a result of the pregnancy. It also typically covers the first 6 to 8 weeks after the birth until the doctor releases the mother to return to work. So again, this is not under Department of Labor, but if the employee is not eligible for FMLA and they are pregnant and do have a reason for being out related to the pregnancy, then they could be protected under the Pregnancy Discrimination Act. Okay, the fifth reason, and I'm sure very familiar for lots of employers and employees, are chronic conditions. This is any period of incapacity due to a chronic condition, which requires at least 2 visits per year to their healthcare provider for treatment, continues over an extended period of time. The condition may cause episodic rather than continuous incapacity, what we would call intermittent leave. A doctor's visit is not required at the time of each absence. Examples of this are asthma, migraines, back pain. These are conditions which can act up at times that we're not expecting it and we don't have notice of, but we are under the continuing treatment of a healthcare provider for these conditions. Number 6, Any period of incapacity for restorative surgery or for conditions that, if left untreated, would result in incapacity of more than 3 consecutive calendar days. So chemotherapy or radiation as an example, getting dialysis for kidney disease is another example. And the final category is any period of incapacity for a permanent or long-term condition under the continuing supervision of a healthcare provider. For instance, if somebody has Alzheimer's or they've had a stroke and are dealing with the after effects of that. And then this is our summary slide, which is a really easy place to just look at all the different reasons to do a quick check off to see if your employee qualifies. Again, it's inpatient care, incapacity of more than 3 consecutive calendar days plus 2 healthcare provider visits, incapacity of more than 3 consecutive calendar days plus 1 healthcare provider visit and a regimen of treatment, chronic conditions, pregnancy, restorative surgery, or illness that is left untreated would result in absence of more than 3 consecutive calendar days, and then finally long-term conditions.
Now, an employee can take leave continuously, but an employee can also need to take leave intermittently or on a reduced schedule basis under certain circumstances. And those would include when it's medically necessary for planned and/or unanticipated medical treatment, for recovery from treatment or recovery from a serious health condition, for the care and comfort of a family member, and as Jen mentioned, that includes psychological comfort, and as well for absences where the employee or family member is incapacitated. If an employee needs leave intermittently or on a reduced schedule for planned medical treatment, the employee must make a reasonable effort to schedule the treatment so as not to unduly disrupt the employer's operations. And this is because intermittent leave can be one of the more difficult types of leave for employers to administer. But it is important to note here that this only applies where the medical treatment is planned by the employee and doesn't necessarily cover situations where an employee has an intermittent absence related to, say, a chronic condition for which they have no notice that it's going to arise, such as asthma or migraine, etc. It's also important to keep in mind that for intermittent leave, an employer cannot ask for a doctor's note for each intermittent FMLA absence. The employer needs to rely on the employee's initial medical certification, or to the extent it requests recertification forms, an employer can use those as well. Now, when an employee calls in and puts the employer on notice or has that conversation, initiating their need for Connecticut FMLA, the employee typically needs to provide 30 days advance notice, and that's to the extent that the need for leave is foreseeable. However, when the need for leave is not foreseeable, the employee needs to provide the employer with notice as soon as practicable, and that's generally within 1 or 2 business days of learning of their need for leave, unless under the circumstances that's not practicable. And when the employee requests the leave, they don't necessarily need to mention the words FMLA initially. The employee can provide verbal notice. It doesn't necessarily need to be in writing initially. And they don't need to say the magic words, I need FMLA. They only need to indicate that they need to be absent and that it's related to an FMLA qualifying reason. So if an employee is calling in absent, they do need to give adequate information to indicate that the illness or injury may be FMLA qualifying. If an employee calls in and only says, I'm sick, that's not enough to sort of meet the threshold to trigger the employer's obligations to give the paperwork and start the process. But if an employee does call in or mentions that they need a leave for a specific medical condition, the best practice in that instance is to give that employee the FMLA paperwork. And when an employee is giving notice, it's really important to make sure that supervisors and managers know that failing to notify their human resources department immediately can put the employer at risk. By failing to notify HR in a timely manner, the result can be that notices will not be provided to the employee in the required time frame, which is usually within 5 days. It can result in absences that should be protected under the FMLA being held against the employee, and it can also result in frontline supervisors and managers handling medical information that they generally should not.
So every time an employee asks for time off from work for something that may be FMLA qualifying, the employer has to do a little bit of an analysis. So if I call up my employer and I say, I have a migraine and I won't be in, then what the employer has to do is, well, is there any job protected leave under one or more statutes? And is there income replacement for this individual while on leave? So those are two fundamental issues that you have to look at when an employee requests time off. So for job protection, you need to look at whether you are covered under the federal FMLA, whether you're covered under the CT FMLA only. Both of them, federal and CT FMLA, running concurrently. Neither one of them, but job protected leave as a reasonable accommodation on some of the laws that we mentioned on the first slide, or maybe there's no job protected leave at all. So you have to go through these laws and see which one the employer is covered by and which one the employee may be eligible for. If the leaves are taken for the same qualifying reason, CT FMLA, federal FMLA, and CTPL may run at the same time. So when I called in about having a back injury and I need it for my own serious health condition, then it's likely that the three laws will run at the same time. So I will be receiving CT FMLA, federal FMLA, and CTPL all at the same time. Connecticut FMLA may also run concurrently with a disability leave, workers' compensation, short-term disability, long-term disability, sick leave, vacation, paid time off. So you have to look at each one of the laws each one of the provisions that you actually have for your employees. If you have vacation time, will that run at the same time? These are all the issues that you have to think about when you are trying to figure out which law applies. So let's take a look at some examples. So an employee needed leave to care for her spouse, and she needed 8 weeks from May 1, 22 to July 1, 22. So that's 8 weeks. Now we know that spouse is covered by Connecticut FMLA and federal FMLA. She also applied for and received income replacement under CTPL. Those are all covered by those laws. So 8 weeks have been used up. Then she asked for leave for her grandparent on September 1st, 2022. So we know she used 8 weeks up above. So what does she have left? She has 4 weeks under each of those 3 laws. But can she use all 4 weeks of each law left to care for her grandparent? And the answer is no. Federal law does not include a grandparent in its covered family members. She can use 4 weeks to care for her grandparent under Connecticut's law and CTPL. Then she will still have 4 weeks under federal FMLA remaining for a qualifying reason, because federal FMLA does not cover grandparent. Here's another example. On April 1st of next year, the employee went on a leave to care for her sibling and used 12 weeks of CTFMLA. And she also was eligible and did receive income replacement through CTPL. Now, on August 1st, 22, she needs leave for her own serious health condition. So what does she have left? She has no CTFMLA available and she has no CTPL available. She used them all up to care for her sibling. But she does have her full federal entitlement of 12 weeks because the leave that she took for her sibling was not covered by the federal FMLA. So this is a circumstance where she can get more leave than just the 12 weeks in a 12-month period. She is essentially going to be eligible for 12 weeks of CTFMLA and CTPL, and then an additional 12-week entitlement under the federal. So you have to look at the reason an individual is taking the leave to see which law applies.
Okay, so one of the ways that employers are going to manage FMLA is through our notices and forms that we're going to have linked on our website. Specifically, we're going to have a bunch of forms, including very much in line with the federal forms, but because our law is much more expansive, we've had to create our own forms, and we will have those available on our website shortly. The employer is responsible for providing all of these notices and forms to the employee, so it's imperative that you know about what is required. The first form that you must send out when employee requests FMLA are the rights and responsibility notice of rights and responsibilities. Along with that, you're going to provide a copy of a medical certification, depending on if the employee is taking leave for themselves or for a family member, and there'll be 2 separate medical certification forms for that. Then when those come back into the employer, they're going to then send out the designation notice. This will let the employee know whether they're getting FMLA or not and all their continuing obligations under the law. We're also going to have a medical certification form for military caregiver leave. And then we're going to link to the federal qualifying exigency form, as our law requires us to follow the federal law in that regard. Okay, so the employer may request a medical certification of the serious health condition by a healthcare provider. It's not required, but we do recommend that employers do this so that you get the right information and do not request information you're actually not entitled to. the employer may attach the job description that should also be taken to the healthcare provider. The employer must give the employee at least 15 days after they receive the form from the employer to return that medical certification. The employer should then also give additional time where 15 days is not practicable and the employee is making a good faith effort. For example, the healthcare provider is on vacation and they cannot get an appointment for 3 weeks. But the employee needs to let the employer know that she needs that extension and the reason for that extension. If the medical certification comes back and is either incomplete or insufficient, the employer must then give the employee an additional 7 days to cure that incomplete or insufficient certification. Incomplete is if one of or more of the applicable entries have not been completed, and insufficient is if the certification is complete, but the information is vague, ambiguous, or non-responsive. At all times, the employer has a right to a fully complete and clear medical certification so that the employer can go back to the employee to have that fixed. The employer may also want or need authentication and clarification on that medical certification. Connecticut FMLA and federal FMLA allows the employer personnel such as human resources, but never ever a supervisor or manager in direct chain with the employee, to call the healthcare provider for authentication and clarification. So authentication is simply that did this healthcare provider sign and date this form? Clarification is if there's something that's not exactly clear and you just need it clarified. However, for clarification, you do need to get the employee's permission for that. And if the employer refuses to provide you permission to contact their healthcare provider, then they need to go back themselves to the healthcare provider and get that clarification for you. The other things that are allowed with a medical certification, if an employer has reason to question the medical certification, it can require a second opinion from a healthcare provider that they have chosen, although that healthcare provider cannot be in their employ. And the employee or the employee's family member must release any relevant medical information pertaining to their serious health condition to that second opinion healthcare provider. Then if the second opinion comes back in opposition to the initial medical certification, then the parties can go to a third opinion, and the employer and employee must agree on a healthcare provider to provide that third opinion, and that third opinion will be binding. If either the employee or the employer fails to act in good faith in agreeing on a third opinion healthcare provider, then depending on which party is not acting in good faith, the first or second opinion will stand. And then finally, on the medical certification, if it is obtained in a foreign country or in a different language, the employee is required to provide a translation for any medical certification that comes back in a foreign language.
So after an employee has submitted their medical certification and has it been approved for their Connecticut FMLA leave, an employer may ask for recertification on a reasonable basis. And what this means is if the serious health condition has a finite fixed duration, the employer needs to wait until that time expires to ask for a recertification. The exception being that if the duration is longer than 6 months, then the employer can ask every 6 months for a recertification in conjunction with an absence. Otherwise, the employer can ask for a recertification no more frequently than every 30 days in conjunction with an absence, unless the employee requests an extension the circumstances of the leave have changed significantly, so the employee is asking for, say, more time than was originally certified in the medical certification, or where the validity of the certification is in doubt. In connection with a recertification, the employer shall pay for any recertification that is not covered by the employee's health insurance, whole or in part, and the employer may not require a second or third opinion on recertification. So the second and third opinion only applies to the initial medical certification. So frequently employers will ask for a recertification where they've noticed that there is a sort of pattern with respect to the employee's absences, such as right before or after a holiday or a weekend. And in that case, the employer may ask the employee about the pattern of absences and require a recertification from the healthcare provider. In that instance, they can provide the recertification form along with attaching the employee's attendance information, just to have the healthcare provider review it and to certify that it either is or is not in alignment with the employee's treatment or the family member's treatment. And so this is a nice overview of the summary of the certification process. In the first instance, an employer may ask for a medical certification to the extent that there are insufficiencies or you need clarification or authentication. You have those options. An employer may ask for a second opinion. The parties may use a third binding opinion. Recertifications can be used periodically during the employee's approved leave. And the clarification on recertification is allowed, but no second or third opinions may be sought during that part of the process.
Is the Connecticut FMLA paid or unpaid? Generally, it's unpaid, except that an employee's accrued benefits, whatever they may have in paid time off, may apply to the leave if required by the employer or elected by the employee. So an employer may say, when you go out on FMLA, you will need to use up your vacation time. If the employer doesn't require that, the employee can request to use their paid time off, their vacation, sick leave, whatever they have. Now, if an employer does require them to use their paid time off, an employee may choose to preserve up to 12 weeks of what they have accrued. So while the employer can require them to use their time, an employee may choose to preserve up to 2 weeks of accrued benefits. So although generally CTFMLA is unpaid, there may be other payments that can run at the same time, such as CTPL, short-term or long-term disability benefits, workers' comp, if the employee meets the eligibility for those other types of leave. And under the CTPL, if you are on workers' comp or receiving unemployment benefits, you are not able to collect paid leave under the CTPL program. In the CTFMLA, employers may use up to 2 weeks of accumulated sick leave for the serious health condition of a family member if the employer has a bona fide written sick leave policy. A lot of times employers will say you can only use sick time for your own illness. Well, In Connecticut FMLA, if you have a separate bank of sick leave pursuant to a written policy by the employer, you can actually use up to 2 of those 2 weeks of accumulated leave to care for a family member or for the birth or adoption.
Okay, so when an employee is returning to work, so employers can require an employee to provide a fitness for duty certification when they are out on a continuous leave of absence and due to their own serious health condition. So prior to returning them to their employment, the employer can require a fitness for duty certification. This is just a simple statement from the healthcare provider that the employee is fit to return to work. However, the employer may ask the healthcare provider to review the employee's job description to consider the employee's job description and providing that simple statement. If the employee has been notified ahead of time that they must provide this fitness for duty certification, then failure to provide it will delay returning that employee to work because they had noticed that they needed to provide it. And so an employee that wants to return to work but has not provided the fitness for duty can be told to remain out until they provide that note. The federal law does allow fitness for duty notes every 30 days for an employee on intermittent leave in conjunction with an absence. But this is only federal, and it must be due to reasonable safety concerns regarding the employee's ability to perform the job. CT FMLA does not allow this for intermittent or reduced schedule leaves. So assuming the employee is able to return to work, they have a right to reinstatement under the Connecticut and FMLA law. The Connecticut law is that the employee must be reinstated to the same, or if not available, an equivalent position upon returning from FMLA leave. In Connecticut, we specifically say that not available means that the job no longer exists. So if an employee has been replaced or their duties have been divided up amongst other employees, then that job still exists. It is still being done, and that employee must be returned. So if you have replaced them, then you need to remove that person who've replaced them and return the employee to that job. Equivalent position means virtually identical in terms of pay, benefits, and working conditions. So it essentially has to be almost the same job. However, there's no right to reinstatement under the following circumstances. After the leave entitlement is exhausted and the employee is not able to return to work, their right to reinstatement under the FMLA ceases to exist. They may be required to be maintained on employment under other laws. If the employment relationship would have ended, regardless of the employees taking FMLA leave, for example, layoffs, and then where the employee obtains FMLA leave fraudulently. If the employee is being laid off, we want to counsel employers that this is well documented, that layoffs were considered and the reason for the layoffs. We do look at that documentation very closely, and we certainly have a very concerned where we see one person layoffs, and it just so happens to be the person who was on FMLA. So it really is up to the employer to prove that the layoff had nothing to do with the employee's FMLA leave. If an employee is medically unable to perform his or her original job at the expiration of their leave, the employer must transfer that employee to work suitable to the employee's condition if such work is available. So if I can no longer do a very physically demanding job, but I can do less physically demanding work or desk work, and I am qualified and you do have openings, then the law would require you to offer me one of those positions. The suitable work may include part-time positions or work at a reduced pay scale. We counsel employers that they may also have obligations under the ADA or Connecticut Fair Employment Practices Act to provide an employee with reasonable accommodations in situations where they're not able to return to their original job for the same reason.
Under the Connecticut FMLA, employees who believe there has been a Connecticut FMLA violation may file a complaint with us, and they can also file a claim in Superior Court. As far as violations go, there are primarily two types of violations that may be alleged under the Connecticut FMLA. The first being interference. So it's a violation of any employer to interfere with, restrain, or deny the exercise of, or attempt to exercise any right provided under the Connecticut FMLA. And this may include an employer wrongfully denying an employee's FMLA leave, discouraging an employee from taking leave, or requiring an employee to work during Connecticut FMLA covered absence. The second type of violation is generally one related to discrimination and retaliation. And so it would be a violation of any employer to discharge or cause to be discharged, or in any other manner discriminate against any individual for opposing any practice made unlawful by the Connecticut FMLA, or because such employee has exercised their rights under the Connecticut FMLA. And examples of this would include an employer discharging an employee for taking Connecticut FMLA or for taking disciplinary action for an employee's Connecticut FMLA protected absences. Do note that it's not just limited to employees. It does prohibit any kind of adverse actions taken against individuals who oppose practices that violate the Connecticut FMLA. Additionally, the law provides that it shall be a violation for any person to discharge or cause to be discharged or in any other manner discriminate against an individual because they have filed a charge or instituted a proceeding under the Connecticut FMLA. So if an employee has filed a complaint with our office regarding a potential violation or filed a claim in court, that is protected. They shouldn't be retaliated against. In addition, with respect to an information who has given or is about to give any information in connection with any inquiry or proceeding related to any right under the Connecticut FMLA, or for any individual who has testified or is about to testify in any inquiry or proceeding. So our office does actively investigate complaints and will speak to witnesses who are involved. And so those individuals who may or may not be employees, they do have the protections of the Connecticut FMLA in participating. And then, as Heidi mentioned previously, where an employer has a bona fide sick leave policy, an employee should be able to access 2 weeks of accumulated sick leave to attend to a serious health condition of a family member of the employee, or for the birth or adoption of a son or daughter of the employee. And it's a violation of the Connecticut FMLA for an employer to deny an employee to access this sick leave. And supervisor liability. So this is something that's important for both supervisors and managers who are on the front lines and speaking to employees who may be communicating with them initially or even throughout their absences, Connecticut FMLA absences, for them to be aware of. Is that supervisors who have sufficient control over the decision to terminate or take adverse action against an employee may be subject to individual liability for violations of Connecticut FMLA. Under the law, an employer can include a manager who acts with some degree of control over the employee, or who discusses or has responsibility to discuss the leave with the employee. So those supervisors and managers can be considered to be acting in the interest of employer. So not only may your organization or entity be subject to liability for Connecticut FMLA violation, but there is a potential individual liability that supervisors and managers may be subject to.
We strongly urge that supervisors get training on CT, FMLA, and CTPL. By doing that, it helps the employer and human resources avoid potential retaliation against employees whose absences are protected. It avoids the improper questions about medical conditions that may arise, and it will help avoid interference with the leave. Now, for employers that may not have an HR department, it's very important that the people in charge understand the parameters of CT-FMLA so that there is no interference with the leave and that there are not violations. And we advise that whoever the direct supervisor is, HR, or the owner, keep detailed and accurate records of FMLA. When an employee calls out, document the reason the employee gives for calling out. Because remember, as it was said previously, if someone calls out and says they're sick, that's probably not going to give rise to enough information for you to consider that may be FMLA qualifying if they just say, I'm sick. But if they call out and say, I'm out with a migraine again, then it's very possible that could be FMLA qualifying and you need to get the paperwork out. You should communicate with the employee in writing. It's so much better to have emails or things in writing, and always respond if the employee has questions. Make sure you let the employee know what they are entitled to and what they are required to do, and just maintain the records in accordance with record retention laws. That covers the review of CT-FMLA in 2022. Just as a reminder, the Connecticut Department of Labor Legal Division has responsibility for CT-FMLA, and the Connecticut Paid Leave Authority has responsibility for all things relating to the paid leave aspect, and U.S. Department of Labor has jurisdiction over the federal FMLA. We will post this PowerPoint and FAQs and other information on our new FMLA website on CTDOL's homepage, so you know where to go to get all the latest information. Thank you.